On July 24th, the Supreme Court was formally asked to overturn same-sex marriage. Same-sex marriage, of course, derived from a 2015 case called Obergefell v. Hodges, in which the Supreme Court declared that same-sex marriage was a constitutionally protected fundamental right. But it seems like this monumental ruling might soon be in jeopardy. Now, in my opinion, the best way to fight against something is to understand it. So let's talk about Obergefell and same-sex marriage from a constitutional standpoint. What was the road that led us to marriage equality? From a legal standpoint, what is the argument for constitutional protection of same-sex marriage, and what are the legal arguments that could lead to this right being taken away? Okay, so before we really dive into it, this discussion is going to be talking a lot about so-called fundamental rights, and a controversial and vague legal term known as liberty. If you'd like more information about these ideas and why they're so difficult for legal scholars to deal with, I'd highly recommend my video on civil rights and the 14th Amendment. I'll put a link to that video in the description, but basically liberty is protected by the Constitution, but not defined by the Constitution. This lack of definition has led to over a century of debate about what is or is not protected by it, but at an extremely basic level, we come to a general agreement, but not complete agreement, that liberty refers to aspects of our society that are so deeply rooted in our history and tradition as to be ranked as fundamental to our concept of ordered liberty. But even that has controversy, as there is a huge amount of nuanced debate about how you determine what is deeply rooted in our history and traditions. With all that said, in order to talk about same-sex marriage, we first need to talk about marriage in general. And to do that, let's go all the way back to 1935 to a completely different case called Skinner v. Oklahoma. At that time, there was a belief that criminality was a genetic trait that could be inherited by a person's parents. In order to prevent criminality from being inherited, the state of Oklahoma passed a law called the Habitual Criminal Sterilization Act. This law said that if a person is convicted of 3 felonies involving moral turpitude in a row, then the state would be allowed to sterilize that person and prevent them from having children. Now, Skinner was a man who had been convicted of 3 separate felonies, 1 count of stealing chickens, and then 2 more counts of armed robbery. After the 3rd felony conviction, Oklahoma invoked the new law and got ready to force Skinner to undergo a vasectomy. Skinner sued, arguing that his rights were being violated, and the Supreme Court agreed and struck down the Oklahoma law. Now, that story is pretty wild and fascinating all on its own, but for our discussion of same-sex marriage, we're more interested in why the court struck down the sterilization law. The Supreme Court, as part of their justification for striking down the law, said that we are dealing here with legislation which involves one of the basic civil rights of man. Marriage and procreation are fundamental to the very existence and survival of the race. There is no redemption for the individual whom the law touches. He is forever deprived of a basic liberty. The court here, for the very first time, declared that marriage is a fundamental right protected by the Constitution. Now, if you read through the Constitution, you're not going to find marriage mentioned anywhere in the document, but the court found the right in that controversial idea of liberty, which is protected by the Due Process Clause of the 14th Amendment. This was huge. If a right is protected by the Constitution, it becomes very hard for the state to regulate it. Now, the court likely didn't fully understand the significance of the door they just opened, but if we then fast forward to 1967, we'll really see dominoes start to fall on our slow march towards same-sex marriage. So, to set the stage, we've got a couple. Their names were Mildred Jeter, who was a black woman, and Richard Loving, who was a white man, and these two wanted to get married. But they happened to live in Virginia, which was one of 16 states that had laws making interracial marriage illegal. To get around the law, Loving and Jeter traveled to Washington, D.C., where interracial marriage was legal, got married there, and then moved back to Virginia. After they returned to Virginia, the Lovings were arrested for being in violation of the state interracial marriage laws and were sentenced essentially to banishment and were prevented from returning to the state for a period of 25 years. The Lovings appealed their convictions, and this is how we arrived at the landmark case Loving v. Virginia. The Supreme Court, once the appeal reached them, doubled down on the holding in Skinner that marriage was a fundamental right and took the next logical step to basically say that if marriage is a fundamental right, then states can't prevent interracial couples from marrying. The court said that these statutes also deprive the Lovings of liberty without due process of law in violation of the Due Process Clause of the 14th Amendment. The freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. To deny this fundamental freedom on so unsupportable a basis as the racial classifications embodied in these statutes, classifications so directly subversive to the principle of equality at the heart of the 14th Amendment, is surely to deprive all the state citizens of liberty without due process of law. The 14th Amendment requires that the freedom of choice to marry not be restricted by invidious racial discriminations. Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state. The court in Loving basically took the door that the court had opened slightly in Skinner and widened it. In Skinner, the court had found marriage to be protected by the concept of liberty. But at this time, you could potentially make an argument that as long as a state provided access to some form of marriage, then the person's fundamental rights were not infringed. After Loving, though, this becomes harder. The Lovings were not necessarily denied the right to marriage. They could theoretically still get married, just not to each other. But the court decided that that wasn't enough. The individual, in addition to having access to marriage in general, must also have choice in who they marry. Fast forward again one more time to 1978 to a case called Zablocki v. Redhail. This case came about because Wisconsin had passed a law that prevented individuals from getting a marriage license unless they could prove that they were up to date on any court-ordered child support obligations they might have. Redhail was a man living in Wisconsin who wanted to get married. However, he had a daughter from a previous relationship and had not kept up with child support obligations. Based on this, Redhail was denied a marriage license. Redhail sued, and when the case arrived at the Supreme Court, the court agreed that Redhail's rights had been violated and struck down the Wisconsin law. In their opinion, the court stated that since our past decisions make clear that the right to marry is of fundamental importance, and since the classification at issue here significantly interferes with the exercise of that right, we believe that critical examination of the state interests advanced in support of the classification is required. The court then went on to apply a critical examination of Wisconsin's reasons for passing the law at issue, and found that they did not justify infringing Redhail's constitutional right to marriage. Importantly, the court also reiterated what it had said in both Skinner and Loving, and confirmed that marriage was a right protected by the Due Process Clause, saying that in Loving, the laws at issue arbitrarily deprived the couple of a fundamental liberty protected by the Due Process Clause, the freedom to marry. So by the time 2015 rolls around and Obergefell v. Hodges lands in front of the Supreme Court, we had, over the course of around 80 years, decided three things. Marriage is a fundamental right protected by the concept of liberty as used in the Due Process Clause of the Constitution. It is not enough that individuals have general access to marriage, but they must also have the ability to choose who to marry or not marry. And when the right to marry is infringed, the Supreme Court must undertake a critical examination to determine whether or not the state is justified in infringing the right. Whether anyone realized it or not, the dominoes had been falling towards same-sex marriage for decades. It was really only a matter of time before someone was able to successfully make the argument that same-sex marriage was really no different from any of the cases that we've talked about so far. And that's exactly what happened in 2015. I'm not gonna lie, this is one of the best judicial opinions I've ever read, like from a literary standpoint. If you've never read the Obergefell opinion, I would strongly recommend that you do, because it's just extremely moving. Let me just read out a few actual lines from the majority opinion's discussion of marriage. From their beginning to their most recent page, the annals of human history reveal the transcendent importance of marriage. The lifelong union of a man and a woman always has promised nobility of dignity to all persons without regard to their station in life. Since the dawn of history, marriage has transformed strangers into relatives, binding families and societies together. Marriage is the coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. Marriage responds to the universal fear that a lonely person might call out only to find no one there. But anyway, the main thrust of the court's argument boiled down to this. If marriage is a fundamental right, as we said in Skinner, as we said in Loving, and as we said in Zablocki, how do we justify denying it based on something as arbitrary as the gender of the people involved? Opponents tried to argue that same-sex marriage could not be a fundamental right because, in our history and tradition, same-sex marriage has always been illegal. Therefore, it cannot be protected by the Constitution. But the court in Obergefell responded by pointing out a major flaw in that argument. In all the cases that we've discussed so far, marriage has been defined extremely broadly. Loving did not ask about a right to interracial marriage. Turner did not ask about a right of inmates to marry, and Zablocki did not ask about a right of fathers with unpaid child support duties to marry. Rather, each case inquired about the right to marry in its comprehensive sense, asking if there was sufficient justification for excluding the relevant class from the right. And the court went on to explain that when the question is framed in this way, there is no legitimate reason to deny gay and lesbian people the right to marry as a class. The respondents have not shown a foundation for the conclusion that allowing same-sex marriage will cause the harmful outcomes they describe. Critics questioned this decision and asked how the court could conclude that all the framers of the 14th Amendment and all the states that passed laws in the aftermath were violating the Constitution. In his dissent, Justice Scalia said that what really astounds is the hubris reflected in today's judicial putsch. The 5 justices who compose today's majority are entirely comfortable concluding that every state violated the Constitution for all of the 135 years between the 14th Amendment's ratification and Massachusetts' permitting of same-sex marriage in 2003. However, the majority opinion responded by saying, I think convincingly, that while people from the past may not have realized that they were violating the Constitution, the nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all of its dimensions, and so they entrusted to future generations a charter protecting the rights of all persons to enjoy liberty as we learn its meaning. These kinds of responses will be familiar to those of you who watched my video on civil rights and the 14th Amendment, as this is another great example of the divide between textualist and living constitutionalist approaches to constitutional interpretation. But even with that interpretation debate put aside, after the cases that we've discussed that led up to the Obergefell decision, it's very hard, in the court's opinion, to argue that same-sex marriage isn't protected by the Constitution. We've said that marriage is a fundamental right. We've said that choice is an important part of that right, and we've said that states need to have a justification that can survive critical examination. Limiting the right to marry based on the gender of the individuals involved just can't stand up to this line of questioning. So really, the Obergefell decision, in my opinion, wasn't as radical as it is often made out to be. Unlike the right to abortion, which is a much more complicated topic, from a constitutional perspective, you really can't argue that the court was reading a dubious right into the idea of liberty. Same-sex marriage is the logical conclusion of all the cases that came before it. If marriage is a fundamental right, then it can't be infringed. That's either true or it isn't. Well, as I set up in the beginning of this video, someone is in the process of trying to get the court to reverse this decision. So let's now dig deeper into the legal arguments against same-sex marriage. Alright, So, I think it's time for me to really make my own perspective very clear. I support same sex marriage, and I believe, based on Supreme Court precedent going back almost 80 years, that same sex marriage is protected by the US Constitution. Hopefully, that perspective was obvious based on how I was talking during the earlier sections, but I'm making it very clear now because we're going to really start getting into discussions that are based wholly on my own opinion. What we're going to do in this section is take a look at some of the more popular legal arguments against same sex marriage as a constitutional right, and then I'm going to give my opinion on why I think each argument is wrong. I am a Juris Doctor, so I feel much more qualified than most to have the opinions that I'm about to share, but I'm not a legal scholar or any kind of law professor, so I am open to these opinions being critiqued and questioned. With that in mind, let's get into it. Let's start with the arguments that I think are thoroughly unconvincing, most of which are going to be coming from Chief Justice Roberts' dissent in Obergefell. The first argument that Chief Justice Roberts makes can be summed up in this short sentence. Whether same-sex marriage is a good idea should be of no concern to us. Under the Constitution, judges have power to say what the law is, not what it should be. The people who ratified the Constitution authorized courts to exercise neither force nor will, but merely judgment. In short, our Constitution does not enact any one theory of marriage. The people of a state are free to expand marriage to include same-sex couples or to retain the historic definition, that being one man and one woman. Chief Justice Roberts is concerned that there is no support for same-sex marriage in our history. He, and people who share his views, are extremely concerned about judges effectively becoming legislators, and believe that interpreting the word liberty broadly allows for judges to force their own personal, social, and political views onto the country, which is seen as extremely undemocratic. In the context of marriage, the Constitution itself says nothing about marriage, and the framers thereby entrusted the states with the whole subject of the domestic relations of husband and wife. Basically, the argument goes, the framers didn't believe that the Constitution prohibited states from outlawing same-sex marriage, and in order to avoid judicial tyranny, we have to abide by that original interpretation of the Constitution. That all might sound fine on paper, but what I find extremely unconvincing about this argument is that Chief Justice Roberts and those that agree with him don't seem to have any problem with Loving v. Virginia. In an attempt to explain how prohibiting interracial marriage is somehow different than prohibiting same-sex marriage, Chief Justice Roberts explains that the fundamental right to marry does not include a right to make a state change its definition of marriage. But what I fail to understand is how Loving can't also be criticized on this very same basis. The Virginia law at issue in Loving prevented interracial couples from obtaining a marriage license. Virginia may not have literally defined marriage as between two people of the same race, in the way that states today have tried to pass legislation that define marriage as being between one man and one woman, but Virginia did make it impossible for interracial marriages to exist. My issue, therefore, is this. Saying that same-sex marriage is not a fundamental right, but interracial marriage somehow is incredibly inconsistent. You either get to choose who you marry or you don't. Laws regulating marriage are either subjected to critical examination or they aren't. You can't have it both ways. The second argument that Chief Justice Roberts and many who agree with him make is that marriage, at its core, has always been between a man and a woman. To change that dynamic, they argue, would be to fundamentally change the whole concept of marriage to the point that we're now talking about something else, something that is not protected by the Constitution. In his Obergefell dissent, Chief Justice Roberts says that this universal definition of marriage as the union of a man and a woman is no historical coincidence. Marriage did not come about as a result of a political movement, discovery, disease, war, religious doctrine, or any other moving force of world history, and certainly not as a result of a prehistoric decision to exclude gays and lesbians. It arose in the nature of things to meet a vital need. He continues to say that this court's precedents have repeatedly described marriage in ways that are consistent only with its traditional meaning. Early cases on the subject referred to marriage as the union for life of one man and one woman, which forms the foundation of the family and of society, without which there would be neither civilization nor progress. In Chief Justice Roberts' opinion, this is why the core structure of marriage is the union between a man and a woman. These arguments, at least the way that I read them, suggest that the marriage that is protected by the Constitution is fundamentally tied to procreation. In his own words, Chief Justice Roberts says that the vital need that caused marriage to exist is to ensure that children are conceived by a mother and father committed to raising them in the stable conditions of a lifelong relationship. Let's for a moment assume that's true, that the US Constitution only protects marriage as a method of procreation, and let's follow this line of thinking to its logical conclusion. Under this theory, would it be constitutional for a state to pass a law that made it illegal for people to get married if they don't want children? Would it be lawful for a state to pass a law that required couples to prove they intended to start a family before they were granted a marriage license? What if a state said that if a married couple failed to conceive a child within the first 5 years of marriage, their marriage would automatically be annulled? Let's say a state passed a law that said that infertile people were not allowed to get married. Are any of these wrong? If the marriage that is protected by the Constitution is marriage that leads to procreation, what would be wrong with the types of laws that I've just described? Again, my basic issue with this line of argument is that it is not logically consistent. Clearly, the hypotheticals I described are ridiculous, but if the right to marriage can be denied to gay and lesbian couples because of their inability to procreate together, then why wouldn't that same logic be applied to a straight couple where the man or a woman is infertile? These two arguments, to me, seem like trying to have your cake and eat it too. If marriage is a fundamental right, then it's all a fundamental right, not just the versions of marriage that are familiar to you. You have to apply strict scrutiny. You have to ask if the state has a compelling reason to regulate the right, and litigation has shown time and time again that you very often cannot reasonably say that it does. Unless, of course, marriage isn't a fundamental right. Which leads me to the final argument against the constitutional right to same-sex marriage that I'm going to talk about. Now, this last argument against same-sex marriage is coming mostly from Justice Thomas's dissent in Obergefell. To be clear though, this is not the first time Justice Thomas has made the argument I'm about to describe to you, and he's not the only one who's made it. In Justice Thomas's view, the right to same-sex marriage doesn't exist because no substantive due process rights exist. None of them. They just don't exist at all. To better understand what Justice Thomas is saying, let's very quickly explain what substantive due process rights are. So there's two different due process rights. There's substantive due process rights and procedural due process rights. Procedural due process rights refer to the literal procedure that is used to take away your life, liberty, or property. Did you get to try your case before an impartial jury? Did you have adequate counsel for your defense? Was the trial itself fair? Stuff like that. Substantive due process rights refer to any right that is protected by the concepts of liberty and freedom. So your right to privacy, the right to choose how to educate your kids, the right to determine if you want to start a family, the right to refuse unwanted medical treatment, and yes, interracial marriage and same-sex marriage. Anything like that. Justice Thomas is saying that none of those rights in the second category exist at all. Here's his thinking. As used by the framers of the 14th Amendment, liberty really only refers to the idea of not being in jail. By protecting liberty, the framers just meant that you couldn't be physically restrained unless you had been found guilty of violating the law. To put it in Justice Thomas's own words, when read in light of the history of that formulation, it is hard to see how the liberty protected by the clause could be interpreted to include anything broader than freedom from physical restraint. Here's what makes this argument so concerning. Unlike Chief Justice Roberts' argument, Justice Thomas's argument is logically consistent. Justice Thomas isn't going to try to split hairs. If you were to ask Justice Thomas, how can you justify denying same-sex marriage in light of the Skinner, Loving, and Zablocki decisions, he would answer that all of those decisions are wrong and need to be overturned. Simple. straightforward. He's not going to try to convince you that gay marriage is somehow different from interracial marriage. He's just going to say that interracial marriage isn't protected either. To be extremely clear, I don't buy into this argument. I agree with the vast majority of legal scholars that believe that liberty was meant to refer to something more than just physical restraint. Further, I think that even if this interpretation is wrong, we're kind of in too deep now. Too much of our society and our legal doctrine has been based around the existence of substantive due process. Overturning it would cause an unacceptable amount of chaos that justifies maintaining it under stare decisis. But unlike Chief Justice Roberts' argument, it's really hard to just completely rip Justice Thomas to shreds, at least not with the amount of time I was able to devote to researching this video. If anyone has any sources discussing this idea, I'd love to read more about it. Please leave them below in the comments. Well, as I mentioned at the beginning, nothing has really happened yet. People don't just get to go to the Supreme Court on a whim. They need to ask the court for permission using what is called a petition for certiorari. The Supreme Court denies somewhere around 97% of the petitions that are sent to them, so it's possible that the request to overturn Obergefell just gets denied outright. However, in order to be granted a hearing, only 4 of the 9 justices need to vote to hear it. Chief Justice Roberts and Justice Thomas are still on the court, and based on their dissents in Obergefell, we know both of them want to overturn it. Then we've got 3 more conservative justices, Justices Gorsuch, Kavanaugh, and Barrett, all of whom were appointed by Trump. For those of you keeping count, that's 5 justices, and only 4 are needed. Considering this is an extremely important case and that at least 2 of the justices feel strongly about it, I'd say that odds are better than normal that it gets a hearing. On top of that, on August 7th, the Supreme Court directed the respondents in the case to file a response brief. A response brief to a petition for certiorari is a weird thing to write. Basically, a petition for certiorari is a long argument for why the issue is important and why the Supreme Court should hear the case. A response brief is making arguments for why the Supreme Court shouldn't hear the case. The Supreme Court only really asks for a response brief if the justices are on the fence about taking the case, so again, the odds are better than normal that the case is taken. This response brief is due on October 8th. Now, I'm not saying that it'll definitely happen, but what I will say is that I wouldn't be surprised if at some point in mid to late October, we get a headline saying that the court has taken the case. If this happens, I'll make sure to update you. So that's all we've got so far. Like I said, I'll make sure to update you if anything changes, so in the meantime, make sure to subscribe so you don't miss it. I'll see you next week.